less access to the individual might actually give more justice and more voice to the voiceless. Now you say, how is that? 60,000 people approach the court every year. 2 of the 5 working days of the court is spent listening to these people and their lawyers. Over 90% of the cases they take are discretionary, meaning they could deny them. The Constitution doesn't require them to do so, but they have usually just add one more layer of appeal, or they skip the lower courts altogether. But of these cases, right, so that crowds out its role of doing the big PILs and doing the big in constitutional cases. Less than 10% are individual rights cases or PILs or constitutional law cases. If it could spend more time on doing those, then it would have a wider impact. And if it could let the cases rest in the lower court, then it would also give people more certainty sooner. So when it takes cases, it delays judgment for an average of 3 more years.
The most delayed cases in the Supreme Court are constitutional bench cases, and constitutional bench cases are cases which involve the most important questions about the Constitution, about holding our government to account, about interpreting the basic text of our polity. These are the most delayed cases.
When you pass a new law, what effect it has on the functioning of the courts is a less studied area. Fortunately for us, we have 2 committees that went into it and gave its recommendations that before the Parliament passes a law, let's for instance take this Unlawful Activities Prevention Act and the amendments made to that act. That one act is having a tremendous impact on the functioning of the judiciary. People are unable to get bail. They have to repeatedly travel between the trial court and the high court and back to the trial court. When they don't get relief of even, I'm talking of Father Stan Swami not being able to even get a straw in a jail, and for him having to go all the way to the Supreme Court for that. That is something that we need to talk about, that we do not focus on the burdens placed on the judiciary in taking up cases. That some cases which should have deserved the priority are not being given the priority. But it's also the perception of the judge before whom the papers are placed as to what deserves priority over which other case.
The Chief Justice of India for the Supreme Court is the master of the roster. That means essentially that the Chief Justice constitutes the bench that will hear a particular case. Now, brushing aside other complexities, when it comes to a constitution bench, which is of 5 or more judges that have to hear important constitutional matters, the Chief Justice gets to decide who will sit on that bench of 5 judges and when that bench will sit. So, for example, the concern about judicial evasion, you don't set up a bench, you don't decide the case, sometimes the case decides itself.
Even if the power is given to the Chief Justice, and the Chief Justice does have that power, whether it's in the Supreme Court or whether it's in the High Court, it must be exercised fairly and reasonably. Not that all the cases of a particular kind should go only to a particular judge. It's not that all cases of a particular type, may be politically sensitive, maybe pertaining to liberty, maybe pertaining to something else, should go only to a particular judge. All judges are equal. Why can't it be given to any judge? Why only to a particular judge?
Popular myth is judges are appointing judges. Actually, it's not true. We have a situation here where the judiciary is in fact not insulated from the other branches. There are a series of informal consultations that go on before you agree on a list of names which will be finally approved for appointment. You're seeing it play out. Some names are just not passed, although they are reiterated by the Supreme Court Collegium. So what you say is right. The judges are able to appoint themselves. Then we should have every decision of the Supreme Court Collegium.
I think the executive government is far more opaque than the Collegium, than the Supreme Court Collegium, right? On what basis does the executive say that, listen, we are not going to appoint a person? They don't even bother to give reasons. And when they do give, some sort of a reason, and the Collegium says we don't agree, they say, all right, you may not agree, but we are still not going to appoint that person. So I think the executive government is 10 times more opaque than the Collegium.